Hi there, I'm Professor Blackmore, and I want to welcome you back to my channel and to another exclusive episode in my podcast series entitled, Has Bishop Squashed the Freak-Off Party? Power Bottom Rumors? And after Brother Youngblood filed recent papers in the Bishop T.D. Jakes versus Duane Youngblood lawsuit opposing Bishop T.D. Jakes' request for expedited permission to serve 2 subpoenas on Brother Larry Reid, I'm coming back to you today to deal with one issue and one question, which is, was Larry Reid right about the identity of Brother Youngblood's attorney? And I don't really have time to play patty cake with this mess today, so I gotta jump right the hell in. And the first thing I want to do is to say, on the record, Larry Reid was right when he said that the attorney who filed the Little Rod case against Diddy is also representing Brother Youngblood. But honey child, the insanity of this mess is so outrageous. I'm having trouble trying to comprehend what in the hell is happening, because everything in this document that Brother Youngblood filed could be taken as a credible, serious document. That is, until you get to the signature block, when it is revealed that this mess was in fact filed by that attorney in New York who also represented Brother Little Rod, i.e. attorney Brother Blackburn. Now, when you look at this docket sheet, you will see that it lists this attorney here that I'm calling Brother Youngblood, attorney number 1, as well as this other attorney here that I will refer to as Brother Youngblood, attorney number 2. And these are both Pennsylvania attorneys. And when you pull this document that Brother Youngblood filed, it appeared that it was filed by Brother Youngblood, attorney number 2. And while you're reading it, it almost makes sense, except for snarky assertions such as this one found in footnote number 1. And so, since it seemed partly credible, I kept reading it to see if it would provide any credible arguments. And while the arguments were partly credible, they were not really attacking the procedural rules surrounding the 2 proposed Larry Reid subpoenas at all. So that prompted me to proceed to the end to see which one of the attorneys drafted it. And when I did, you would not believe my shock to realize that the attorney who authored this document was the same attorney that filed the Little Rod lawsuit against Diddy, also known as Brother Attorney Blackburn, as reflected in this signature block. Now, I cannot tell you how out of order this is, because he has not been granted permission to practice law in this court. Nevertheless, I'm going to call this attorney Brother Youngblood, attorney number 3, aka Brother Attorney Blackburn. Now, I think we all know that this attorney is licensed in New York. And as far as I know, unless he knows something that I do not know, in order for him to sign documents in this case, he would need to file a motion pro hac vici, and until the judge signs the order, he cannot sign documents in this case. For example, you will see that Bishop also has an attorney out of New York on his team in this case. And you'll see that this particular attorney filed a motion pro hac vici with the court, which was granted by the judge. And instead of taking Bishop's warning seriously, when his attorneys mistakenly referred to him as a defendant in this case, as he references in footnote number 1, Brother Attorney Blackburn writes this snarky footnote anyway, which makes me think that he's daring Bishop to add him as a defendant in this case. Now, all along, I have been saying there might be jurisdictional issues that will make it difficult for Bishop to sue him in this Pennsylvania court. But now, Brother Attorney Blackburn has essentially subjected himself voluntarily to this court's jurisdiction by signing this document, when he did not have to do this. And to me, this seems like it just could be one of the biggest mistakes that he could have made in this case. And the only thing that I can hope is that Brother Larry Reid does not let anybody influence him to make any appearance in this case whatsoever until and unless he is directly ordered to do so by the judge. In other words, unless Larry Reid receives an order directly from the judge in which the judge specifically orders him by name to do something, and this includes a summons if he is ever added as a defendant in the case, because a summons is an order of the court. But unless Brother Larry Reid receives such a document, if I were him, I would not do anything to voluntarily subject myself to the jurisdiction of this Pennsylvania court. Now, in addition to this era of possibly voluntarily subjecting himself to the jurisdiction of this Pennsylvania court, I just don't see the logic in Brother Attorney Blackburn putting his name on this document. And that is because if you want to convince the court that Larry Reid does not have any documents to show that you are one of the potential defendants in the alleged extortion conspiracy to extort millions of dollars out of Bishop, or that it would be a violation of procedural rules of the court to allow the subpoenas to be served on Brother Larry Reid, it would be more credible if it were coming from Brother Youngblood, attorney number 1, and or Brother Youngblood, attorney number 2, and not the attorney who is alleged to be a part of the extortion conspiracy, i.e. Brother Attorney Blackburn. And so, these are the major flaws that I see. Notwithstanding, I'm not going to waste my time going over this document because, in my opinion, in addition to any procedural issues regarding engaging in discovery before the judge holds his Rule 26F conference, which is what Bishop is asking the court to do, I personally feel that the subpoenas are defective, and that requires a discussion about Rule 45, which I did not see anywhere in this document purportedly prepared by Brother Attorney Blackburn. Now, in episode 19 of this podcast series, I discussed all of the Rule 45 defects in the subpoenas addressed to Brother Larry Reid. So if you want to get caught up on that, you can watch that particular episode, and I'll place a direct link in the description section below. Now, instead, I want to discuss the reasons that Brother Attorney Blackburn is not a serious individual, allegedly. And the main reason is because Brother Attorney Blackburn has not been admitted to practice pro hac vici before this Pennsylvania court. And so, I want to talk about the top reason why Brother Attorney Blackburn cannot be admitted pro hac vici to this court or any other court for that matter. Now, when you go to the court's website, it provides information which is substantially the same for most United States district courts regarding requirements to file a motion or application pro hac vici to the court, which requires the attorney to attach an affidavit to the application. Now, regarding this affidavit, the rule states, quote, "The affidavit must list the bars of any state or of any United States court of which the affiant is a member in good standing. The affiant must attach to the affidavit one current certificate of good standing from the bar or the court in which the affiant primarily practices. The affiant also must list and explain any previous disciplinary proceedings concerning the affiant's practice of law that resulted in a non-confidential negative finding or sanctioned by the disciplinary authority of the bar of any state or any United States court." End quote. Now, back in February of 2024, Brother Blackburn was trying to pro hac vici another attorney into the bar of the New York United States District Court when the judge in that court issued a February 15, 2024 show cause order based on what the judge perceived to be Brother Blackburn's violation of Rule 11, which basically requires attorneys to be truthful and ethical in documents that they are filing with the court. In this order, the judge states, quote, "On February the 1st, 2024, Brother Blackburn filed a letter accusing defendant's counsel of refusing to mediate with a mediator of color." Brother Blackburn's letterhead in that letter includes his name and adds federal membership in the Eastern District of New York, the Northern District of New York, the Western District of New York, the Southern District of New York, the Northern District of Illinois, and the District of New Jersey. Nevertheless, the clerk of the court does not have a record that Tyrone A. Blackburn is a member of the bar of this court. End quote. Now, the judge stated further, quote, "It is further ordered that Brother Blackburn shall show cause at the March 5th, 2024 conference why Rule 11 sanctions should not be imposed and why you should not be referred to the New York State 2nd Judicial Department Attorney Grievance Committee for the following conduct: failure to conduct a reasonable inquiry into the citizenship of defendants prior to filing this mess, allegedly, in this action on December the 14th, 2023, falsely representing your admission to practice in this court, and failure to move for admission to practice in this court pro hac vici, or to associate with counsel admitted to practice in this court." End quote. Now, after the March 5th, 2024 hearing, in her April the 3rd, 2024 order, the judge makes a complete record of everything Brother Blackburn had done in that particular case, as well as all other cases that he had filed that were dismissed by other United States district judges. In this April the 3rd, 2024 order, the judge states, quote, "There is a basis to believe that Brother Blackburn is filing cases in this district without diligently investigating the existence of either jurisdiction or venue as required by Rule 11. At the March 5th conference, defense counsel purported that Brother Blackburn had told her he filed this case in federal court because doing so would make the press more likely to pick up on it. A reasonable inference from Brother Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Brother Blackburn has called defense counsel in this action a disgusting racist for rejecting his preferred mediators. Brother Blackburn filed a wholly inappropriate 53-paragraph affidavit containing multiple irrelevant and scandalous accusations against Fisher, who is one of the defendants in that particular case. Regardless of Brother Blackburn's intentions, his actions in this case and prior cases indicate a repeated failure to meet his Rule 11 obligations. Significant resources have been spent by judges of the court and defendants named in actions he has filed, i.e., Brother Diddy, to address glaring deficiencies in his filings. A referral to this court's grievance committee is warranted. In conclusion, Brother Tyrone A. Blackburn is referred to the grievance committee of this district for such action as it deems appropriate. End quote. Now, as you can see from the docket sheet for this case, in addition to admonishing and reporting Brother Attorney Blackburn to the court's grievance committee, she also dismissed the case. Thereafter, Brother Attorney Blackburn filed an appeal which was dismissed. And so, the judge's sanctions order against Brother Attorney Blackburn, referring him to the court's grievance committee, remains in effect. And so for these reasons, Brother Attorney Blackburn will have to disclose all of this to the Pennsylvania court, and I doubt the Pennsylvania court would grant an application allowing him to be admitted pro hac vici as an attorney for Brother Youngblood in that court. Now, he may be in good standing with the New York bar, but due to the pending grievance committee issue in the United States District Court for the Southern District of New York, it would be difficult for him to be admitted to any U.S. District Court. I am not saying he can't, but I doubt he would file an application requesting to be admitted, because he would have to also file a sworn affidavit, either swearing that he does not have any grievances filed against him, or he would have to disclose the recent pending grievance that was filed by the New York federal judge, Judge Coate. And so, ladies and gentlemen of this church house jury, what do you think about all of this mess, honey child? I mean, I have never encountered an attorney that has the nerve to execute these types of transactions in a court of law. This is not like anything that I would ever have the nerve to do. And I really expect Brother Youngblood, attorney number 1, to withdraw from this case when he is made aware of the New York federal judge's order reporting Brother Attorney Blackburn to that court's grievance committee. But in the meantime, please let me know what you think about all of this mess, honey child, by leaving your comments in the comment section below. And I hope you'll also give me a big thumbs up. And I hope you'll also consider donating to this video and my entire channel ministry by donating to the Professor Blackmore Cash App. And I hope you'll also subscribe to my YouTube channel and set your notifications, and then be sure to turn on your notifications, specifying which notifications that you want so that you'll be notified whenever I come back with more hot tea from the church house, the courthouse, and everywhere else, honey child. And whenever I come back with more hot tea in my podcast series entitled, Has Bishop Squashed the Freak Off Party? Power Bottom Rumors? And please also follow me on TikTok and Instagram.